Hi, welcome to Case Law Minutes. My name is Joel Persaud. I'm a student at Osgoode Hall Law School. In this episode, we'll be looking at Ontario Court of Appeal case Mullin and Sherlock. Here's just a quick disclaimer. This presentation is meant to provide general legal information only. If you have a legal problem, please consult a lawyer who might be able to help address your specific circumstances. Before we start, let's look at why this case is important. This case is important because it provides an answer to the recurring issue where judges strike out pleadings in family law proceedings after one of the parties fails to provide complete disclosure. The Ontario Court of Appeal sets out the general framework for motions to strike because of non-disclosure. In this case, a husband and wife, before they married, lived together for about 13 years. They got married in September 2012, but divorced in June 2013. Eventually, the wife commenced an application against the husband, claiming spousal support and equalization of net family property, asserted a joint family venture, and claimed she had entitlement to the value of the husband's business. The wife served a detailed request for information on the husband, seeking extensive personal and corporate disclosure. Despite multiple orders requiring further disclosure and questioning, the husband failed to provide sufficient disclosure and failed to provide answers to undertakings. The judge warned that if the husband persisted, his pleadings would be struck. The husband did not provide sufficient disclosure or sufficient answers to his undertakings. In fairness to the wife, seeing that the wife couldn't proceed with her claim without the husband's information, the husband's pleadings were struck by the motion judge, and the husband's trial participation rights were limited. Thus, the husband appealed to the Ontario Court of Appeal, arguing that the motion judge erred in striking his pleadings. So, the question for the Ontario Court of Appeal was this: did the motion judge err when he decided to strike the husband's pleadings? The Ontario Court of Appeal said no, and the appeal was ultimately dismissed. Here is a summary of the test that the Ontario Court of Appeal used in examining the motion judge's decision to strike a pleading. First, is there a triggering event, specifically evidence of noncompliance, that justifies the striking of the pleading? Second, should the pleading be struck partially or completely, or is an alternative, less drastic remedy more appropriate? A judge must consider multiple factors, including complexity and a serious effort to disclose. Third, if the offending party's pleading is struck entirely, what are the appropriate consequences for the party whose pleading was struck? Although drastic consequences are required by Rule 1.8.4, the judge has discretion to vary the consequences based on the circumstances. Relying on this test, the Ontario Court of Appeal offered the following reasons for dismissing the appeal. When striking out pleadings for failure to obey disclosure order in the family law context, the judge must be satisfied that there is non-compliance with a court order before considering factors in determining the appropriate remedy under Rule 1.8c of the Family Law Rules. In order to determine the appropriate remedy, the motion judge must consider the following factors: relevance of the non-disclosure, its significance in hindering the resolution of issues, the context and complexity of the issues, meaning that the judge should show tolerance for delay in complicated cases, but show little tolerance in less complicated cases. Also, judges must consider the seriousness of efforts made to disclose, explanations offered by the defaulting party for inadequate disclosure, and any other relevant factors. The Ontario Court of Appeal noted that the judge did not strike the appellant's pleadings solely because of his failure to disclose, but also because of his failure to answer to his undertakings and refusals. The judge correctly considered all the alternative remedies before deciding to strike the husband's pleadings. Relying on Rule 1.8c, the judge rightly determined that the husband's non-disclosure was relevant to the case and that the husband breached court orders for disclosure to frustrate the wife's efforts to pursue her claims. The Ontario Court of Appeal, however, acknowledged the motion judge's failure to identify which pleading he was striking out, which violates Rule 18C of the Family Law Rules. Thus, the Ontario Court of Appeal altered the motion judge's order to permit the husband to make an opening statement, cross-examine his wife and witnesses at trial, and also to make closing submissions. In short, the Ontario Court of Appeal determined that the husband would not be allowed to pursue his own claims, but would be allowed to test the respondent's claims. If you are interested in reading this case, you can find this case on CanLII. Feel free to use this link. My name is Joel Persaud. Thanks so much for watching Case Law Minutes.